Good afternoon. If everyone could take their seats, please, and we'll go on to our next session of the day. I'd like to invite the panelists to take seats. And so I will turn you now over to Antonio Capobianco, who is the Deputy Head of OECD Competition. Antonio.
Thank you, Linda, and thank you very much. And good afternoon to all of you. Welcome back after the lunch break. I think I want to welcome especially those online. I'm sure are waking up in the Americas, so we can almost smell the cappuccinos and the freshly brewed coffees on their desk. So welcome to those who are joining online, and for those in the East, I think it's getting close to the end of your working day, but please bear with us. I think the program this afternoon is quite exciting, very interesting. We're starting with a panel on interim measure in antitrust investigations. It's really my pleasure and an honor to moderate the panel and to have such an esteemed group of speakers, which I will introduce you in a moment. I'll take a few minutes just to set the stage for the discussion. And let me start the panel with a quote from Wyatt Earp, probably the most famous marshal and law enforcer in the Wild West at the end of the 19th century, and I'm sure you all know him because he was involved in the mythical gunfight at the OK Corral, and so much celebrated in many Hollywood movies. And when he was asked by someone why he was such a good gunfight, very good at gunfight, he said, "Fast is fine, but accuracy is final. You must learn to be slow in a hurry." And I thought that just like Wyatt Earp, modern law enforcers like the competition authorities need to intervene as quickly as possible to prevent that anti-competitive conduct may harm consumers, but need to be sure that their intervention is accurate and that does not incur into error that can actually stifle competition rather than protect it. So I choose these particular quotes because it seems to me that time, and especially the passage of time, and the need to preserve effectiveness of the enforcement action while the investigation is taking place is so central to the policy reasons for the revival of the use of interim measures that we have witnessed in recent years. Now, the tension between speed and accuracy has emerged very clearly in digital markets, where the complexity of cases requires lengthy investigations before final decision can be taken by competition authorities and before courts can then have the time to review them in appeal. And we know that finality is so important for businesses, but it may come only many years after the conduct has taken place and the investigation has started. But what happens to the effects of the conduct during the investigation? How can we protect consumers while the investigation unfolds? How to ensure accuracy when intervening quickly, and how to avoid those enforcement errors that can harm competition rather than protect it. So what are these interim measures? These are measures that are granted by public authorities or by courts with a protective and corrective objective to provide temporary relief pending the outcome of a case. There are various similarities and differences across jurisdictions, but just to sum up, in general, interim measures are granted in exceptional circumstances. They typically require two conditions, the meeting of two conditions: the likelihood of success on the merit, the so-called fumus boni juris, and the urgency to prevent harm during the investigation, so the periculum in mora. They can often be imposed by the competition authority itself, but in some cases, agencies need to apply for them before an independent court. They can be asked by the parties, by third parties, or sometimes the authority itself can, of course, impose ex officio interim measures. As you've heard this morning, the topic was discussed extensively here at the OECD in the Competition Committee last year, so we'd like to sort of give you a little bit the main conclusion from that discussion. So interim measure can certainly be a powerful tool to improve the effectiveness of antitrust enforcement and to preserve competition during the antitrust investigation. That said, they should not be seen as a tool operating in a vacuum. They can influence, of course, the outcome of the antitrust investigation itself, and more importantly, they may produce effects that are hard to reverse in practice. So the use of interim measures should be carefully considered on a case-by-case basis, and really they require a balancing exercise to mitigate the risk of errors, both type 1 and type 2 errors, so false positive and false negatives. Now, competition authorities considering whether to adopt interim measure really are confronted with two questions. The first question is whether the expected benefits from the measure is greater than its costs, and if the competition authority should be risk neutral or risk adverse when exercising this balancing exercise. So that's a little bit the trade-off when it comes to imposing or adopting interim measure. Now, the fast-changing nature of digital market has increased the call for more frequent use of interim measure, and we've heard also this morning a flavor of that discussion. Indeed, and of course, always subject to meeting the legal and evidentiary standards, interim measure may be particularly appropriate in antitrust investigation concerning markets or services that have the characteristics leading to fast tipping. In this context, interim measure can bring substantial benefits to investigative action of competition authorities. However, the ultimate solution to speed up investigations in digital or over fast tipping markets, they may create, in some instances, wrong incentives to slow down the main investigation. Once you have achieved some results, you may decide to slow down to some extent your main proceeding. So interim measures remain a powerful tool, and they should be used, however, in a careful manner. If wrongly adopted, they can also do serious harm to competition and to consumers, as well as damage the action and the reputation of competition authorities, with potential spillovers effect on the main investigation and beyond that. So some have argued that cases based on well-established rather than novel theories of harm may be better suited for interim measures. Now, you can see that the discussion that took place here in Paris really lends itself to be approached from different angles. Some of them are technical perspective, and other more policy-oriented questions. And I've encouraged the speakers, the panelists, to really reflect on a number of issues in their initial 10 minutes presentations. Some of the questions that I put to them, and I leave them, of course, to pick them up in their remarks, is what are the costs and benefits of adopting interim measures? What are the expected benefits of interim measure? Are they greater than their costs? What are the risks of our competition authorities being involved with more regulatory measures, regulating the behavior of firms today in the uncertainty of what will be the outcome of the investigation? What is or what should be the role of competition authorities, and of course, as well, in designing, implementing, and monitoring these measures, the implementation of the measures? How do we balance effectiveness of antitrust enforcement, so the speed and precision where we started from, with due process considerations in interim measure proceedings? Is there a risk of an excessive use of interim measures? Benoit this morning talked about the risk of competition authorities becoming regulators. Is there a risk also of that in the extensive use of interim measures? Now, to discuss this, and of course, other fascinating questions around interim measures, we have the pleasure of having with us three experts who have looked at this question really closely, but from different perspectives. I will introduce them now. On my right, we have Isabelle da Silva. She's a conseiller d'État, the French highest administrative court, the Conseil d'État, where she presides the work of the Sixth Chamber. You know her very well. She has been at the helm of the French Competition Authority between 2016 and 2021, and in that period, among many achievements, she also imposed, the agency imposed interim measures in a number of cases, and I'm sure we'll hear her perspective on that experience. Next to Isabelle, we have Caio Mario Pereira Neto. Caio Mario is a professor at FGV Law School in Sao Paulo, Brazil, but he's also a private practitioner with Pereira, Neto, Macedo, Rocco. So he brings really to the panel his academic experience, but also experience as a practitioner in a jurisdiction which has used Brazil, which has used interim measure in recent time. Next to Caio Mario, we have Professor Heike Schweitzer. She's a well-known professor of economic law and competition law at the Humboldt University in Berlin, and some of her recent research has focused on the economic and legal implication of digitalization, and she has acted as special advisor to the EU Commissioner Vestager on the future challenges of digitalization for competition policy, and in that context, she really reflected upon the use, the benefits and costs and challenges with interim measures. For those of you who have studied the program carefully, I was supposed to introduce a fourth speaker who unfortunately could not make it today. Pharyngitis had kept him in bed today, but I want to say a word about Matteo Giangaspero. He's now Senior Managing Counsel on Competition Law with Booking. He's very well known to all of us here because he spent several years at the competition division here at the OECD, and he's actually the author of the background paper that we used for the discussion last year. So I want to introduce him, even if just virtually. I'm sure he's following us. So Matteo, please recover quickly, and we look forward to having you here another time. But that said, I think we also want to hear from all of you. We want to hear your views, and we have reserved, of course, time after the presentations from the panelists from questions. Those of you in the room who want to ask a question, well, you just need to raise your hand. We'll give you the floor. But for those online that are following the debate, the discussion online, there is a Q&A function on the platform. So please type in your question. We'll bring them to the podium later on. We also value your opinion and your views on the main issues that our speakers will discuss. So be ready with your phones. So you will be able to scan a QR code that will appear on screen, on the big screen behind us, with questions and multiple answers. So we'll then bring the results of those surveys back to the expert, and we'll use them to start maybe a conversation later on. Maybe we can actually start putting up the first question. You can scan the QR code that you see now on screen. If it doesn't work for some reason, you should connect to the menti.com website and use the numerical code that you see on top, you see there on the slide. And that will bring you to the first question, which is, are the expected benefits of interim measure greater than their costs? So the poll question, we have 3 of these questions during the panel. They will remain open for a few minutes, so you can, of course, use your phone to give us your answer. Now, finally, and before I give the floor to our expert, let me remind to those of you who would like to dig a little bit deeper on the topic that we have produced a background paper. This publication is available in the back of the room. Here it is for those online. And it's also, of course, downloadable from our website, so please feel free to take copies. I also want to thank Caio Mario because he has produced a blog that we have circulated on our website dealing with some of the issues that will be for discussion today. So with that, without further ado, I'd like to give the floor to Heike first to introduce the topic.
Thank you, Antonio, also for setting the stage. I feel that I cannot really answer all the very good questions you have asked, and will rather focus on presenting 3 points, which I think may be a bit controversial, and therefore may be a good starting point for discussion. I will focus my remarks on interim measures in the EU and basically also on interim measures in the field of abuse of dominance cases. I know that interim measures can be used in all settings, but this has been the background, EU and abuse of dominance, against which I have developed my 3 points. So I give you a spoiler of the 3 points first, and then dive a bit into each of them. My first point would be, we have, and this has been said many times now, we have started discussing interim measures against the background of an experience of overlong abuse of dominance cases. And here, interim measures seem to be a way out. And my first point will be, well, if we really have a problem with overlong abuse of dominance cases, we should first also try to find out why they are too long and what we can do to make them shorter. Trying to substitute interim measures for solving a problem that they are not meant to solve will not be very helpful. This will be my first point. Then I have a second point, and it is very much related to that. Interim measures, they are not just a pause button for proceeding in infringement proceeding, but they also can be used strategically because they change the incentives of the defendant. So the defendant will now feel pressured, so to speak, into negotiations much more than before. This may be good for an effective law enforcement, but it will be good only as long as the legal test we use for interim measures is well aligned with the legal tests that we use for showing the infringement in the end. So if we decouple the two tests, we will then run into risk of having too many false positives, and then in the end this will not protect competition but harm competition. So that will be my second point, and then my third point will be still, although I think we should not change the test we currently have in EU law for interim measures, because I think that test is not decoupled. It's well aligned. The interim measure test is well aligned with the substantive test for finding an infringement, so we should not change that. Still, there are things to be done in the EU. My impression is that we should change the precedent we currently have in the IM assaults proceeding, where the court of first instance found that interim measures should not be used where the law is not clear. But if we cannot use interim measures in cases where the law is not clear, then we cannot use them at all in the moment in abuse of dominance cases. So yeah, this will be my third point. If I have time, I have two further points, but let me first start with these 3 points. First point, interim measures must not be a substitute for the reform of substantive competition law if there is a need to reform substantive competition law. So there are many good reasons to talk about interim measures, and I have found it very interesting to learn about the very different legal standards that are used across the world for interim measures. And also to see how we see different patterns of use in different jurisdictions. But one core impulse for the debate on interim measures in the EU has really been the experience that in abuse of dominance cases we have a tendency to have very, very long proceedings, especially in the cases on the large digital platforms. Here it seemed that having an interim measure could solve the problem. But my point would be, yes, in these digital platform proceedings, maybe we do need interim measures at times in order to push the pause button, in order to have time to bring the proceeding to an end. But the core problem probably is, the reason why we have these long proceedings is that the law on abuse of dominance is not clear, and that we need adjustments, especially in the realm of or when we deal with digital platforms. And if that is the problem, then we should solve that problem. And we should not try to find a kind of a way around by having interim measures and imposing interim measures. This hasn't been done in the EU. We haven't had all the large digital platforms cases have not been dealt with by way of interim measures, so this is not the problem. I just caution to make broader use of interim measures in these cases in the future. Okay, then comes my second point. We should be careful not to decouple the legal standard for having an interim measure from the legal standard that we use to show an infringement on the substance. So the primary purpose, obviously, of an interim measure is to kind of have time to bring the proceedings to an end without competition deteriorating in an irreversible manner. For this, interim measures are a very good and very effective tool. But simultaneously, and this has been mentioned frequently already this morning, interim measures also change the dynamics of an infringement proceeding. They change the dynamics sometimes in very useful ways. For example, a competition authority who is thinking about adopting an interim measure will speed up the collection and processing of evidence in order to make a good prima facie case very quickly. Also, thought will be given to the design of remedies at an early point of time. I think that's very useful. Also for the defendant, an advantage of this will be that the defendant will be aware of the legal arguments and also the evidence that's available at an early point of time. But then, once an interim measure is adopted, the whole incentives change for the defendant. Before, the defendant may have had an interest in delaying the proceedings. Afterwards, the interest is to bring the proceedings to an end, and typically defendants will be more willing to engage in negotiated solutions. So this can, therefore, interim measures can be used, and I think Benoit also mentioned that earlier on. They can be used strategically to increase the readiness of the defendant to cooperate in an infringement proceeding. Now, I don't think that's wrong. I think this can be a useful way to use interim measures in a way that promotes the effectiveness of competition law enforcement, but only to the extent that the legal standard for imposing interim measures is well aligned with the legal standard that we have for showing an infringement. If the two legal standards are decoupled from one another, then there will be an incentive, or can be an incentive on the part of the competition authority to use the interim measure tool too frequently, to nudge defendants into negotiated solutions, even where these are not justified based on substantive competition law. And in the end, this will lead to more false positives and to a decrease in competition, or to harm to competition, not to a better protection of competition. Therefore, I think we should not change the legal standard for interim measures we currently have in EU law in Article 8 of Regulation 1/2003. Here, the test is we have to have a prima facie infringement, and secondly, there must be risk of serious irreparable damage to competition. There has been a discussion to reform Article 8 to have maybe a test of a possible infringement, and maybe instead of harm to competition, harm to individual competitors. And I think this would be a wrong way to go for the EU. I think this would be decoupling the standards for interim measures from the standards we use in the infringement proceeding. So third point, still I think there is a need for reform in the EU. We are currently discussing the reform of Regulation 1/2003. Of course, we can then also think about reforming Article 8 of Regulation 1/2003. I don't think we should do that. I think Article 8 is okay. In Germany, we have engaged in such a reform. We have clarified that a prima facie infringement means that an infringement is more likely than not. I think that's fair enough. I think that's what a prima facie case means. But we have also said that it need not be serious irreparable damage to competition, but it can also be serious irreparable damage to an individual undertaking. I think that's wrong. In the member states, we have had such reforms. I don't think the EU should head into that direction. What could be done, maybe, in terms of reform is something on the procedural side. Max Kadar has written about that, and I don't want to dive into that. The point I want to make is that we maybe have wrong precedents in our European law currently regarding the types of cases where interim measures can be usefully applied. And there is this precedent by the Court of First Instance, which in IMS Health, which says that where the law is not clear, interim measures should not be used. But as we all know, currently the law, competition law is quickly evolving, and we need changes in the law to deal with the new situations, the digital markets, which are characterized by different features and need a different standard of intervention. So if we want to use interim measures in these cases, and I think there are maybe good reasons to use them in these cases, there must be a possibility to use interim measures also in cases where the law is not yet clear. And I don't think there are hurdles, good convincing hurdles to use interim measures in these cases. Still, the authority will have to show that there is a prima facie case, and this will be subject to judicial review by the court, also maybe by way of interim relief. Now, the one problem I see here is that in the EU, this interim relief proceeding will be done by the president alone, or the president of the Court of First Instance or of the ECJ. If an interim measure is based on a novel theory of harm, I think the judicial review should be done by a full chamber, maybe even if it's an important change by a grand chamber, but still on that basis, it may even be a good idea to have a judicial review regarding a new legal theory of harm, maybe in abuse cases, at an early point of time, because this will give the court a chance to give some sailing instructions to the Commission at an early point of time. So I think I stop here and...
Thank you, Heike. And I think you, in the last part of your comments, you touched on a question that I wanted to ask our audience. So maybe we can put up the second poll question for participants here and online. In which cases are interim measures more suited? So these novel cases or more cases with well-established and disputed theory of harm? It would be interesting to know what you think. So there is a QR code. And again, if it doesn't work, use the numerical code that you see here on the slides. Caio, maybe I can give you the floor now.
Thank you very much, Antonio. And let me start by thanking OECD and yourself, Antonio, for inviting me. It's a pleasure to be here. I think the Competition Open Day is a great initiative to engage with the international community, with experts outside of OECD, authorities. I think this is a great exchange. So thank you very much, and thank you to my fellow panelists for this discussion. So I think this panel couldn't be more timely. I think there's really more interest on interim measures in the past few years. There's a push for more fast reactions from authorities and a push for a possibility of intervening early on in investigations. So this is the tool that's being discussed to deal with this issue. In my view, we need to think about interim measures from this perspective of a provisional remedy, right? So it is a quick fix that the authorities are trying to put in place in order to avoid irreparable harm during an investigation. So we need to think of this with the same challenges of designing remedies, but also understanding there's additional constraints in designing this type of provisional remedy, right? It's not the same constraints of final remedies after a full-blown investigation where authorities are clear about the infringement and where they can design a more permanent fix to solve the competition problem in the market. So I think it's helpful to think about what are the constraints, what are the additional constraints that authorities face when they're designing an interim measure to avoid irreparable harm during an investigation. And I think we need to start by probably what's the biggest and the foremost constraint in this context, which is the lack of information, or at least limited information that's available when an interim measure is taken. Because these measures are usually evaluated in the beginning of an investigation, or at least in a point of the investigation that's a bit further away from the final decision. And at that point, there is very limited information available to take a decision. The second constraint is that this is usually a temporary remedy. So you're not thinking about a final fix in a way of dealing with the problem that will solve it for good, but actually as a way of dealing with the problem during the time of the investigation. So you need to design a temporary remedy. And this is very much associated with a third constraint, that is, it must be reversible. It must be fully reversible. Because authorities are not sure yet whether there is an infringement, it must be designed in a way that, in the end, if authorities do not find an infringement, they must be able to revert that remedy entirely. And that's a huge constraint, right? In itself, it's a huge constraint. And with that comes another one, that is adaptability. Because this decision is being taken under little information or limited information, then throughout time, authorities are going to have more information about the infringement, more information about the impact of the conduct in the market, more information about the remedy designed to deal with that potential infringement during the investigation. And they may need to adapt that. The initial interim measure may be too narrow or may be too broad. It needs to be adapted throughout time. And that's another feature of these types of measures. It can't be inflexible. It needs to be flexible enough to be adapted. I think another constraint is still that deciding on interim measures means imposing a more significant burden on authorities to deeply evaluate what's the benefit of that provisional remedy against the potential harms, not only to defendants, but to consumers, to the market, to third parties, to all the stakeholders involved. You're taking a decision early on without a final finding of infringement, and therefore all those concerns must be taken into consideration. And finally, there are very specific procedural safeguards to be considered, right? In most jurisdictions, there is a presumption of innocence. There is a principle of freedom of enterprise. So in the absence of a final finding of infringement, you need to consider the best available information and grant the rights to defendants to put forward their case and to consider the arguments in order to deal with these procedural requirements. So these are important constraints. And when we think about final remedies, these are additional constraints in what authorities face in designing final remedies. And these constraints, I think, make it particularly challenging deciding on interim measures and even the design of this provisional remedy there. I think they also serve to remind us, a point that Heike has made, that interim measures have a very particular purpose, that is really avoiding irreparable harm during the investigation, and it should not be overstretched to solve other shortcomings of competition law, whatever they are. But especially and in particular, in a moment where we're discussing many other regulatory tools, many other ways of dealing with competitive concerns, it should not be a substitute for regulation. Regulation requires a different type of setting. Many times it requires new legislation, or at least new rulemaking, different procedures, procedural safeguards, different tools, different monitoring. So it's not the same as a regulatory substitute. And we should be very careful with that, because there is a tempting situation where competition authorities may go down that road. But the other point that I'd like to make is that because of all these constraints, and especially because of the limited information, these decisions are more subject to errors, right? So authorities can get it wrong, and can get it wrong both ways. They can act when they shouldn't, or they can not act when they should act to avoid an irreparable harm. And we need to think of that with a narrow cost framework in mind. And I think that's where whenever authorities are facing a decision about entering measures, they need to have some type of ways of dealing with potential errors of that decision. And I'd like just to point to some elements in this idea of a narrow cost framework. So one first element is that in designing any remedy, and especially provisional remedies associated to interim measures, I think there is a possibility of a compounded error effect, so of two errors that can be compounded. The first potential error is really evaluating the likelihood of an infringement, right? So authorities are faced with limited information, looking at the conduct and trying to evaluate whether that could be an infringement after a full investigation. and they get it right, and they can get it right, or they can get it wrong, right? And in the end, they may change their mind about whatever the likelihood that they found in the beginning. But there's a second potential error here, that is the design of the remedy itself. So even if the authorities get it right and say, look, this is a potential infringement, it's very likely that it's going to be a final decision of finding of infringement here, the provisional remedy may be too broad, may be too narrow, it may be wrong in some way, it may not be adequate to deal with that particular problem. So I think what authorities need to understand is that, and that's, I think, a very important point of reflection, is that these two errors can be compounded in a way that the error becomes even bigger, right? Because if you get it wrong about the infringement, and if you design a remedy that is overly broad, for instance, then that can have a bad impact in competition in the market and developing of that particular market. So you need to try to minimize this compounded effect. That's one thing that I think should be considered when thinking about potential errors coming from this discussion. A second thing that we need to consider is this right balance, and there's a lot of discussion about this right balance between potential harms coming from type 1 errors, from over-enforcement, right, from decisions to act when authorities should not act, and the harms coming from type 2 errors, from decisions not to act when acting was the appropriate decision here. So I think comparing, balancing this is particularly important in the case of entering measures. And here, I think the insight of Giulietti Caminaggi in a technical note to OECD last year, another paper with a couple of co-authors, is quite interesting for the discussion that we're having. And their basic insight is that the most important thing here is the asymmetry about the two harms, right? Is whether, not only whether there's the magnitude of the harm, if it's an intense harm, but whether there is an asymmetric magnitude of these two harms. So if authorities should be more inclined to adopt an interim measure whenever the harm from type 2 errors, the harm from not acting, right, when they should act, is substantially higher than the harm from type 1 errors, from the harm of over-enforcement. So this asymmetry of the two harms of potential errors should favor one or the other decision. I think that's a very important and key insight to be dealt with here. And finally, to touch upon another question that Antonio has made, is that I think ideally the evaluation of these different types of errors should be somewhat risk neutral. And here I think in the past, to some extent, the analysis was possibly biased to avoid type 1 errors, right? To avoid over-enforcement, to avoid taking a decision of entering measures when that decision was not the best decision to take. Now there is a big call in some instances that this changes to a bias to avoid type 2 errors, to avoid under-enforcement, so that authorities should be bolder and should take decisions and take more risk of over-enforcement in order to avoid under-enforcement. I don't think either bias is good in this discussion. I do think that these are very context-specific decisions. They depend upon the facts on the case. They depend upon the available information at the time of the decision. They depend upon the type of remedy that's going to be designed. They depend upon many different issues. And if you can make the best decision possible, trying to avoid errors on both sides, that would be, I think, the best way to go. And just, if I can just turn a couple more minutes just to talk a little bit about the Brazilian experience here. I'll just do in a very high level here, Antonio. That is, Brazil has been particularly active on interim measures in comparison pretty much to any jurisdiction as far as I can tell. The Brazilian Competition Authority has analyzed between 2012 and 2022 45 requests of interim measures. in 10 years. 2012 is important because it's when our new competition law came into force. And out of these analyses, CAGI granted 18 interim measures in this period, which is a large number by any account. But what's most interesting is that this number increased a lot in the past few years. So if you look from 2012 to 2017, CAGI issued only 2 provisional measures, 2 interim measures. And then from 2017 to 2022, another 17 came up. So this shows some things going on, right? Some things potentially changing. Of course, it could be by chance. Of course, it could be only that some cases were more complicated and required interim measures by then. But it could also be something else. It could be also a trend in changing the balance and changing the potential bias towards type 1 or type 2 errors. I think this is something that we need to, I think it's too early to account for that, but I do think that it requires careful attention what's going on and whether this trend is going to follow on. Let me pause here and thank you again for the floor, and thank you again for having me here, Antonio.
Well, thank you, Caio Mario, for bringing the Brazilian experience and for asking the question of how to strike the right balance between over-enforcement and under-enforcement, which is the third question we wanted to get your views on. So if we can put it up on screen, so you can use the QR code to answer, is there any risk from an excessive, quote-unquote, use of interim measures, or how do you strike that right balance that Caio and Heike have been talking in their presentation. So while you answer the question, I give the floor to Isabelle. And I hope you haven't lost your instinct as an enforcer now that you are in a court, because you have been quite active, especially in this area. So we'll be very interested in getting your sort of views, the lessons learned from that experience at the French Competition Authority.
Thank you, Antonio, and I would like to thank the OECD and yourself for inviting me at this session. It's a great pleasure to see friends and colleagues from last years. I have to say, for those who are not in the room, that we are subject to very dazzling light. So I will confess right away that I think interim measures are a key tool in the enforcement toolkit, and that globally, I would say that I have a very positive view of the way this can be used. So maybe to enter into a bit more detail, because I think interim measures today, as has just been said, it's really at the center of the debate of which way should enforcement agencies go. But you also have some very serious legal debates about the presumption of innocence or due process, for example. The first, when you think about interim measure in Europe, you often take the view that France has been the most active agency in this field. I would like to remind us also that Belgium has done quite an extensive use of the interim measure tool, and also for very significant cases, and I will give a few examples in a moment. You could say that the way the Commission recently decided to use interim measure again, I think is also the result of the debates we had over the years within the ECN about what was the good use for interim measures and what lessons could be learned from the French experience. So I think the debate of today is whether we are now very far from the IMS health jurisprudence that in effect completely sterilized the use of interim measure by the Commission, and are we at the start of a new era of interim measure, especially given the fact that the DMA provides for a specific interim measure tool that might be used in the future within the scope of the DMA. I think that when you look at France, the diversity of cases in which interim measures have been used illustrate the fact that we have had some far-ranging, far-reaching interim measures, and that those cases were not limited in any way to very traditional cases. So if you think of the jurisprudence that Heike was referring to, definitely there have been interim measures in very novel cases, and I will give the example in a moment. One of the reasons, I think, why we have seen so much enforcement in France and so little in the EC until the Broadcom case is really in relation to the legal test. I think the legal test is the basis and the start of everything. But of course, you also have the enforcement policy of a given agency at a time, because the legal test is not what will make the agency decide to prosecute in a certain way. And to start with the legal test, I think that the key is the fact that in the French legal framework, you do not have to prove an infringement to be able to issue an interim measure. So we have two criteria in the French law, as in Article 8 of Regulation 1/2003. The denounced facts must constitute a conduct contrary to Article L 420.1 and L 420.2, which are the abuse of dominance and collusion. And also, and this is a different with the emergency test that Heike was referring to, this conduct must constitute directly and certainly a serious and immediate threat to the general economy, to the concerned sector, to the interest of consumer, or to the complainant. So you see a big difference with the legal test as applies in European law, and I think I approve this wide-ranging interest in terms of how the conduct affects, for example, an undertaking, and not only the market as a whole. And I would really like to reaffirm that the key, the reason why the authority was able to issue those interim measures is the fact that there is no need to characterize an infringement at this stage of the procedure, and this has been confirmed by the Paris Court of Appeal and the Paris Court of Cassation. But this doesn't mean that any possibility of an infringement is enough, of course. So in French, we say that the conduct is susceptible de constituer un manquement au droit de la concurrence. So there is this test, but the difference with the second test is that on the one hand, on the substance, you have a possibility of an infringement, but you have to prove an effect. So the second condition is really you have to prove that there is a direct and certain effect of the conduct. So depending on the case, if you see no effect of the conduct, you may stop there and you do not have to look into the legal question of whether there is an infringement. So why has the French approach been remarked as quite active in the interim measure? I think that the reason why we have had this range of cases is because we did not feel that we should limit ourselves to very traditional cases. So you often hear in the doctrine and based on the IMS health jurisprudence that interim measures is not a right tool when you have novel questions. And I really disagree with this because I think that the law does not provide for any condition related to it being a traditional or novel cases. I have reminded you of the two criteria, and there is nothing about novelty in those criteria. So I would like to start by reminding us of the energy providers case of 2014, in which the issue was the possibility that the incumbent gas provider, former monopoly, at a time when the market was opening to competition, would have abused advantages directly related to its former monopoly to prevent competitors from entering the market, and more specifically, using the database of traditional clients from the time of the monopoly, and using all this information to try to keep as many clients as possible and also drive new clients to its client base. And the competitors were arguing that this provider was using the advantages from its monopoly in a way that constituted an abuse of dominance. So in this decision, the authority found that there was possibility of such an abuse. And for the first time, it ordered this company to provide its client database to its competitors at the time when the market was opening, and not only the name and addresses of the clients, but also all the data about the consumption of the client, how much they were consuming every year, and the profile of the clients, and this was individuals, but also businesses. And another feature that is interesting in this case is that for the first time, we had ordered that a database be made public to other parties. But of course, there was the GDPR to consider, privacy law. So in the way of designing the remedy, we consulted with the Data Protection Agency to make sure that in transferring this sensitive data would not be, of course, in breach of GDPR and data protection law. It's interesting to say something about the way the court looked at this decision. And it is quite a remarkable judgment by the Court of Appeal in Paris that decided on this decision, because it was issued in only 2 months. When I looked at the date a moment ago, I was surprised that the court had been able to decide in 2 months on this case, and in a very detailed manner after an oral hearing. And one of the points that was made during in front of the court was that the company was complaining that this interim measure was definitive and irreversible, because once it had given the database to the competitors, it would be done, and the damage to itself would be lasting. And so this is an interesting point by the Court of Appeal, because the Court of Appeal stated that if there was such an abuse, the only way to stop this abuse was to give access to the database to the competitors, because the main company was using the database, and that if in the end the decision on the law was different, then it would be enough to ask the competitors not to use this data anymore. So I wanted to follow up on the point that was made by Caio Mario, also about the presumption of innocence. The Court of Appeal decided that this was no breach of the presumption of innocence because it was necessary to intervene. And another interesting aspect of this judgment is that the Court of Appeal added to all the elements that the authority had stated as constituting an abuse. The Court of Appeal added even more elements. So in a way, they were even more convinced than the authority that it was necessary to issue such an interim measure. The second example I wanted to take was the Google Amadeus case. It's a very different case about online advertising and the way you can buy words to make advertising on Google search. Another interesting feature about this case is for the first time in this interim measure decision, the authorities stated that the way Google was defining and applying rules to businesses on this specific online market could constitute an abuse. So in a way, this was novel because we had never had a case in the jurisprudence, French or even European at that time, that had defined such an abuse. So we were not stopped by the fact that it was the first time we had such a case. And we asked for Google to apply a very wide-ranging set of rules concerning the businesses, asking them to inform of any change of the rules in a very clear manner. And this decision, once again, was completely confirmed by the Court of Appeal. A third case that is really, I would say, the most exceptional case of interim measure we had so far is the Google and related rights press publishers case. This is quite an exceptional case because there again you could say that the question was novel. The question was whether the new law that had defined a new regime of related rights in France, transposing the very recent related rights directive that had stated the press publishers were entitled to have some remuneration for the use by online platforms. The issue was that when the law became applicable, supposedly the law asked the platforms to discuss an agreement with press publishers about content, and Google decided to tell the publishers, either you give me your agreement to keep on using press articles for zero, otherwise I will stop having your content on the Google pages and the different services. So this interim measure was decided by the authority in a matter of 5 months. It was a rather complex case even to have a preliminary review because it raised a lot of legal questions, whether the fact not to apply a law related to property rights, intellectual property rights, could constitute an abuse of dominance. So this was the first time we had a case of that type, and there had been cases similar in Spain and Germany which had not concluded that there was an abuse. And in the end, we felt that it was indeed a possibility of an infringement, and we issued a very wide-ranging set of measures asking Google to negotiate in good faith with press publishers and adding a number of conditions that they would not be able to degrade the economic situation of press publishers through other services. And so this was confirmed by the Court of Appeal then again in a matter of months, but this was not the end of the movie, because a few months after that we had to issue a decision condemning Google for having infringed this interim measure set of injunctions, and we issued a very heavy fine of 500 million euros. And this, after that, was concluded by the authority a few months ago by a commitment from Google to integrate all the obligations that were set forth in the interim measure in a set of permanent commitments to negotiate with press publishers. So this was a difficult case. So we see we did not have a decision on the merit on this case. So a little bit like the Broadcom case, this concluded with a commitment. But I really feel that it was necessary to act fast, and this we could know after having a detailed investigation and a detailed oral hearing with all the parties involved. But it is certainly a case that is quite exceptional, because we had never had the need to issue such a heavy fine for non-compliance with interim measure. So to close, I would like to say a word about the Apple ATT case. So this was, there again, a digital case about the new type of operating system that Apple wanted to introduce for a smartphone. And the community of the ad tech industry complained that it was completely disrupting their businesses and that they would lose severely in terms of turnover and profit because of this decision by Apple. So in the end, after a few months of investigation on this interim measure, we decided not to issue any type of injunction. And still, I think it is important that you have some decisions in which you do not grant what the complainant asks, because the most decisions that we have are refusal to issue interim measure. Still, I think this decision is interesting because it states a number of legal points in terms of what Apple could and couldn't do. Because one of the difficulty of the case was to know if what Apple was doing was compliant with the GDPR law. So we consulted with the Data Protection Agency on several difficult points of law. And in this decision, we decided for the first time to affirm the principle that a company has the right to impose some rules on other economic agents, given the liberty of enterprise, but even though you are a structural platform. So it was the first time that we had reminded that even if you are dominant or a structural platform, you are still entitled to impose some rules on your business counterparts, but with, of course, an important caveat, that is, you must not do it by going against competition law. And this was in the fact of the case. We decided that we had no element sufficient to be a possible abuse in that case. But we also decided to continue the investigation on whether Apple was doing some sort of self-preferencing. So this is a case that should be decided by the agency in the next few months. So to conclude about this diversity of cases, I would like to say that the key is the legal standard. We need to apply all the legal standard, no more than the legal standard. There is no need to prove an infringement, but there must be objective element. So I think that the question of risk does not really come into our decision making. It's not the point of being risky or not. And when you are in an agency, you take risk every day in a way, because you are never sure that the Court of Appeal will agree with what you decide. But it is important not to create a blind spot by saying, for example, you only issue interim measure in traditional cases. And of course, I would say that all the more with all we have learned about the digital economy, the need to move fast. And I agree with Heike that it doesn't mean that we should keep very long investigation because we have interim measure. It is not the case. You will always need, I think, a very urgent procedure, as you see in other parts of the law. I think that in the administrative law system of which I am a part of now, The revolution for us was the introduction of a fully fledged interim procedure that is really functioning very well and that is different from the procedure on the merits. Second, you need to find a good balance internally, not to spend too many resources on those interim measure cases, because of course the goal of the agency is to conclude the cases on the merits. Third remark, the courts have been generally supportive of the decision of the authority. I only think that it's because they felt we had done a good job in terms of the law and the facts. But this is also, I think, a key to the success of a good interim measure system is that the courts decide fast. So in the different cases I mentioned, the Court of Appeal was able to issue the decision in a matter of months, and it is not always the case in other jurisdictions. And of course, when you have a fully functioning interim measure system, it creates a deterrence. And it is also appealing to companies that come to the agency with a lot of demand for interim measure, because it's interesting for them to be able to use this tool. And a final word about the changes driven by the ECN Plus directive. As you know, with ECN Plus directive, all the member states now have a system of interim measure which is obligatory by the law. And we decided with this occasion to change the legal system in France, because until then it was only possible to have an interim measure if a complainant came to the agency. And we decided to introduce the possibility of ex officio interim measure with the agency to align with what is possible under merit, and also because we had perceived that in the digital economy there might be a self-restraint from companies to go against the major platforms. So it was interesting for the agency to be able to start interim measure ex officio without waiting for a complainant. Thank you.
Merci Isabelle. Thank you also to Caio and Heike. You have heard experiences from different jurisdictions. You have heard the benefits from using interim measure, but also the risk or the costs with using interim measures. Before we display the results of the polls, maybe we can take a few questions now to react to what you've heard, and I also sort of invite the other panelists to react or to comment to what they've heard on the panel. I know someone is monitoring the Q&A functions on the platform in case there are questions from those connected remotely. There is a question over there. Maybe if you can introduce yourself. A microphone is coming your way, Peter. And please address the question to the panel or to a specific panelist.
Yeah, thank you very much, Antonio. I'm Peter Thierry, a private practitioner from Austria. I just wanted to add on your discussion and maybe introduce another piece of information on my jurisdiction, which is Austria in this field. We've had quite a few interim measures cases before the Austrian cartel court, very many actually, and it won't surprise you that these cases mostly come from applications in abuse of dominance cases. However, the Austrian system has it that these cases are not brought by the Austrian competition authority mostly, but by private applicants who have in Austria the possibility and the rights to bring their applications directly to the courts, which then have to decide in these cases. So that's why we have very many interim measure cases, and some of those have even made it to the European Court of Justice by way of preliminary applications, questions being posed before the Court of Justice. So this is a subtlety of Austrian law, but does it tell us something about how interim measures can be applied in a, let's say, more business-to-business context? Is there something to be learned for competition authorities who can themselves apply interim measures? That would be my question to the panel. Thank you very much.
Please, anyone who wants to go first?
It's an interesting point because in many jurisdictions, and France is the case, businesses have a choice to go either to the authority or either to the commercial judge with the same type of demand. And in some cases, they do both. So we have parallel proceedings. So it's very often that we have proceedings in the authority, and at the same time, the parties go directly to the judge and try to have this type of injunction. So it's something we are used to. And we are quite aware that there may be some type of forum shopping between the two jurisdictions. But in a way, some companies feel that they take a risk if they have an interim measure case, because the authority might decide very soon that their case is worthless or issue a decision that might be perceived as not going their way. So in some cases, they feel maybe that they will have more chances going to the commercial court. So you have this type of strategy and debate within the lawyer community of which is the best way to go.
I think we're in a similar position in Brazil, where the party can actually go both to court or to the authority, but I do think that usually they go to the authority, actually, because it's more specialized, because it's going to look at that particular complaint, usually from a perspective that is more detailed in that manner. So I think that's been the case, although in Brazil we also have the opportunity, and the authority has the power, as in France, to issue ex officio entry measures as well. But I think most of the actions is within the authority, although the law provides for a standing to go to court directly asking for entry measures.
Maybe a related questions I may have is, so what is the purpose of the objective of this interim measure? Are we protecting individual interests of firms, a complainant that goes to a court because has a personal interest, or are their objective is to protect competition or consumers in general? That's where maybe the agency, the competition authority, has a public interest, of course, objective, intervenes. I wonder, I mean, Heike mentioned that in her presentation, but I wonder if there's any sort of reaction to what is the ultimate purpose of these interim measures.
Maybe I can react to that. I think in Brazil it's usually to protect competition, not to protect competitor. That's how it's designed by the law. Of course, when a competitor is pushing for that, it's always portraying the entry measure as something that's protecting the market. But CADE has often made this distinction of saying, look, this we wouldn't protect a particular competitor, but the market itself, and that would be the purpose of a general competition law. Of course, there's other cases on competition, more on the commercial side of competition, that's called unloyal competition. That can be a more private case, like with trademark and things like that. That can go to court in protecting competitors in certain cases. But as far as antitrust law, that's the market is being protected.
It's true that the legal test and the procedure will be different in front of the commercial courts, but sometimes they might have the same effect. But to come back to the previous point that is interesting is, what is the test that you have to prove, and is it legitimate to issue an interim measure when the emergency factor is the impact on the company? There are some cases like the energy case I was mentioning, where the authority felt that the second condition was direct harm to competition, opening of competition in the market, and harm to consumer losing better prices. But I think it's interesting that in the Google Amadeus case I mentioned, the authority softened a bit the condition when you only have an implied harm to a given business. And I think that this was legitimate because this company was complaining that they had a loss of turnover of 70%. And in the former jurisprudence, it would have been difficult for them to consider that it was enough. But I think we also learned about the debate about Google Shopping and the competitors having disappeared when the decision comes in the end. And I think we must be more mindful of the immediate effect on given businesses, given the fact that we have the first legal test, that is possible infringement. So in any case, we will not change the legal test about what constitutes an infringement, and this is of course related to competition as such.
Thank you. There's one question from the back.
Yeah, I'm Thomas Lübeck, is my name. I'm also a private practitioner from Germany, and I wish to echo what the Austrian confrere said. It's also my experience, especially in defending dominant companies, that our courts, but also courts before in foreign jurisdictions, are very trigger happy, always talking about civil courts. And as the Austrian confrere said, you know, if you go before, as a complainant, go before a competition authority, you may be anticipating, you know, 3 years down the line. If you go to a civil court, you have a good case. it may be 3 weeks, including the second instance in some cases. And so perhaps the competition, the agencies should then be somehow trained by national judges. And I think the key difference is that if you are a national judge, also in patent law, but think of the juge d'instruction on the criminals here who have to take interim decisions every week on granting bail, yes or no, so they are kind of sociologically in a different situation. And I think the key difference is that they need to decide. They can't evade the decision. If you are a judge, you're expected to decide in an interim case within a couple of days or weeks. You can't deprioritize the case. You can't refer your case to some other authority. And also you have much more, that's actually makes it even more difficult for the judge. You have no possibility to consult with your boss. You cannot consult with some other department. You cannot ask the economist, chief economist of your organization. So even in that limited circumstances and limited tools you have, you're still able to grant injunctions in rather complex cases. Yeah? In Germany, you have actually also had injunction cases in digital markets now, where the issue of tipping was solved, I think quite satisfactorily solved, in an interim measures case in, I'd say, a couple of weeks, perhaps a couple of months. And so, perhaps there should be more interaction between competition agencies and those people in the courts who, are expected to take interim decisions almost every day. Thank you.
I'm not sure it's a question, but it's a comment, but maybe you have been an enforcer and a judge, so maybe you can say a few words about this interaction.
I think it's a very interesting point, and I'm quite convinced that there are some cultural elements in terms of use or preference for interim measure. I remember that often we discuss these issues with colleagues at the Commission or in Germany. There was the idea that if I give time to an interim measure procedure, I'm wasting time that I should be giving to the main procedure on the merits. And I think maybe it's not the right way to look at it, because I think you can earn a lot of time if, in a way, you solve the case at the interim measure stage. So this does not depend on you, but if a company sees that an interim measure has been issued against itself, that the Court of Appeal has confirmed, maybe this can give an incentive to settle the case through commitments, for example, which is, I think, it's one of the best case scenario of what we have seen with the Broadcom case. So sometimes people tend to disagree and they say that only the final decision will be the ultimate good. But I think that this type of scenario can be quite effective for competition and also save time for the agency, even though it is not the ultimate goal in itself.
I'm told that there are questions also. Heike, sorry, please.
Actually, a question following up on that to both of you. How many of these cases of interim measures have then ultimately been resolved at the interim measure stage by way of a commitment? How many of these cases have led to a final infringement decision? Because this would tell us a lot about the possibility to make strategic use of this instrument. And with regard to the strategic use, I see the benefits, but I also see the risks.
Almost all interim measure decision issuing an injunction end with a fine or a commitment, but it is not an absolute, and it really depends on the way we had found elements in the interim measure. Will the later investigation bring new elements that were not present when we issued the decision in a matter of months? So I think it's important always not to give interim measure proceeding too much of an importance. For example, I was very careful at the authority not to write it as I would write a decision on the merit. Always when something is not sure, you do not write it as being certain, because you only had a very short period of investigation. So I think I would not be able to give you an example of an interim measure followed by a decision saying there was no problem at all. Maybe there is one, but it doesn't come to mind. But this doesn't mean that it's always a principle that it's the same as a condemnation, because I think that's really not the case.
Okay, let's take one question from those participating remotely, and then I would like to take really 10 minutes to go over the results of the poll questions. Maybe there's more food for thoughts from those results, and we'll come back to you with more questions if there is time at the end. But Zoe, maybe you can ask a question from from the remote participants.
Absolutely. Thanks, Antonio. I think this is a question for Isabelle from Clementine Massant. So what procedure requirements apply in France in terms of sharing access to the evidence that you've relied on when making an interim measure decision with the case party, obviously before a final decision has been made?
I'm not sure I totally understood the question. Because the investigation until the interim measure decision is really the same principles apply as in on the merits. The difference is that the way the investigating team will notify that they could propose an interim measure is of course much shorter than notification de grief in the decision on the merit. But it is true that one of the challenges we have to conclude this part of the procedure is that we have all these debates that we will have on secret des affaires, confidentiality. So one of the issues for the teams is really to select the elements that are necessary at this stage without going in the full procedural constraints that we have for the later case. But I'm not sure if it's related to the question as such, but there are also cases in which having a hearing at this early stage can really help also the investigating team, because, for example, in France we have this separation between the investigating team and the board, and in some cases, like the Apple case I was mentioning, some points have been settled in a preliminary fashion in this interim measure decision, and in a way I think it helps move forward the decision. Of course, this does not have the same value as the final decision on the merit, but it's a way of clarifying some points of law with the intervention of the board, which is, of course, not the same as the investigating team. So I'm not sure I fully answered the question, but I will come back if necessary, of course.
Thank you, Isabelle. Maybe we can put up the results of the first poll question and see whether any of the panelists wants to react to what the audience think. The first question was on the benefits and costs of interim measures and whether the expected benefits outweigh the costs or greater than the costs. Let's see what the respondents have said. So it seems the large majority, 61%, think that interim measures should be used very carefully as they are quite intrusive, and if wrongly used, they do serious harm to competition and ultimately to consumers. I don't know if we can keep the results up so that maybe inspires a reaction from one of our panelists. I don't know if Caio, you want to react to that. And we have 26% that calls more for a balancing exercise. Very few, only 13% seems that they should be used without too many concerns. What do you think?
I think they certainly should be used carefully, but I do think that as put, the question deserves an answer it really depends on the context, right? I think that's the usual answer that a lawyer would give. But I do think that we need to consider many different layers here, and I think one of the layers is really what's the magnitude of the potential harm that's being avoided. The other, as I mentioned when I talked, was the asymmetric sense that the harm of not issuing an interim measure versus the harm of potentially issuing the interim measure, so we need to compare that. And also one way of dealing with that is designing a remedy that's sufficiently precise, or that is sufficiently designed to be narrow enough to reduce the risks of potentially damaging competition. So I think you need to factor in all these issues in order to evaluate whether the costs outweigh the benefits or vice versa. I think that's the way I would think about this.
I don't know, Heike, Isabelle wants to react to this one, or?
Well, I personally, first of all, I would say the same thing as you did. It depends on the context. But then I belong to the camp who says we should be very careful using this instrument. It seems, interestingly, one of these cases where the jurisdiction you come from kind of also influences the way you think about it. So in Germany, the Bundeskartellamt, even under this new provision, which is much broader, which would allow the Bundeskartellamt to be much more generous with interim measures, the Bundeskartellamt has not used it. not in a single case since 2019, but they found it useful. I think there was one case where because of the Bundeskartellamt threatened to use it, and because of that threat, the company then basically agreed to commitment. So I think even having this instrument is already important for a competition authority and can make competition enforcement much more effective. But on that basis, having a good, sound system of interim measures, I think competition authorities should try to be careful and use the instrument cautiously, also because I think the value of having final decisions is very important. And especially now in the digital realm, I really want to see the decisions, the final decisions, in order to help us to understand the cases, to develop the law. If a case is closed at the commitment stage after an interim measure, you in the authority, you will know what happened. I will not know. And I think so many people will not be able to think about the correctness, so that the debate will be much more confined than once we have a final decision. So I think this value of having a final decision is very important.
I think you could say that in France, interim measure decisions are part of the jurisprudence and also the decision by the Courts of Appeal, because they are quite substantial, so they are part of the global jurisprudence, so that's an element. And I would like, well, about the questions, it's like when I read a magazine and I don't find myself satisfied with any of the answers. So, but what would have happened if the Commission had issued an interim measure a few months after Google changed its web pages in what became the Google shopping case? Would it have been better if the Commission had found that there was a possibility of an abuse and that maybe some of the changes were not should be temporarily stopped? I think it's a question that we have to ask, because all this debate about the lengthy procedure and the fact that all the competitors are dead, I think this is something we must ask ourselves. So are there not some of the cases that the Commission decided in which it could have been a good case for an interim measure?
Which ties in very well with the second question we asked our audience, and maybe we can display the results. The question was precisely which type of cases interim measure are better suited, and we had already a discussion between the difference between novel, complex cases as opposed to more traditional, well-established theories of harm. Let's see what our audience thinks about this. It's, I would say, a divided room, almost 50-50, but certainly not for novel and complex cases. Only 8% chose that answer. Most of the answers are for, for dynamic and fast-changing markets, which show risk of tipping.
I think 1 and 3 are the same cases.
Yes. All right. Any reaction to this one? Which type of cases are better suited? Do you agree with the poll, with the results, or you have different views?
Well, I think Isabelle and I had definitely a different view. And I don't really understand why we should not use them in novel cases once a competition authority is convinced, or let's say prima facie convinced, that they have a good case. It's not that we will not have judicial review. So the courts will look at it, and the courts will also have an opinion of whether this is a good case or not. But if we only say these must be traditional cases, then the most important cases where harm may, irreversible harm may occur, may not be subject, or the tool of interim measures may not be available for these cases. Therefore, I don't really understand fully the concern, given that we have judicial review.
Just complementing that, I think first, it's of course easier to issue interim measures in cases where you have very consolidated theories of harm, and that you can evaluate that and have a very strong idea that there's going to be a finding of infringement in the end, right? So that's one point. But I agree with Heike that sometimes you need, you may need to take an interim measure in a new case. I think the big issue there in these novel and complex cases is how certain or how positive the authority is about the potential finding of infringement. If there is a big question mark still, I mean, that's a big problem. That's when you can incur major errors there. And the other thing is, you should design a remedy that is appropriate, that is narrow. If you're testing the limits of a new theory of harm, you shouldn't go with an overbroad remedy, right? You should be careful with the remedy, the provisional remedy that you're designing. I think that's one of the big issues as well on this discussion.
All right, we have a few more minutes. Maybe we can show the results of the third poll question, which provocatively asks if there are risks from an excessive use of interim measures. Let's see what the audience think. Yes, there are risks. 83% thinks it's risky, but they can be managed if interim measures are proportional, temporary, and reversible. Very few think that the risks are minor. Any reaction to this one on sort of how to design this measure to avoid regulatory risk or regulatory drifts of competition authorities?
Well, here I think there is the point that, to my understanding, but I think my co-panelists will disagree, the risk depends on the legal standard that we use. So if the standard is, as you said, it is in France, a possible infringement and some harm even to an individual undertaking, then, to my understanding, we have a risk of an excessive use. Because you don't, a possible infringement in a novel case, let's say, everything's possible. And harm to an individual undertaking you will always find. So what then exactly is the filter where you say no, in this case not apart from good judgment by the authority? And then it all becomes a question of, do I trust the authority or do I not trust the authority?
Maybe to illustrate that, we would need more detail, but what I would call the first condition, so the possibility of an infringement, you need to have a number of elements in that, because you need to establish that there could be dominance, so this is not something you find every day, so you have to define a market and give some elements of dominance. So this was rather easy for the Google cases I mentioned, because we had decisions by the Commission and some jurisprudence, so that is of course mandatory. And of course it's not just a theoretical possibility that you need some factual elements that this specific conduct could be an abuse. So of course a possibility would be much too wide a standard to issue an interim measure. So I think that it's really in the way you define this possibility of infringement. And it's true that when we had the discussion about the ECN Plus directive, we had a lot of discussion also about whether we should go more explicitly against the IMS Health jurisprudence. Was there a way in which a directive could adapt this standard? But it was felt that it was not really by changing the wording that we would reach the effect. It was more confiding in the General Court to change its jurisprudence, given all the debate that it's now many years. And I think that it will be interesting to see a case in front of the General Court, but of course this will depend on the way the European Commission goes.
Well, I think unless there is one last burning question from the audience, which I don't see anyone with their hand up, I think I want to thank all of you, of course, for being our fourth expert, sharing your views on these sometimes difficult questions. And please, I have one last request to join me with a round of applause to thank our panelists, Isabelle, Caio, Mario, and Heike, for their insights. Thank you all very, very much.